way, and they can begin to participate, and it opens it to a larger group. Obviously, the pandemic is the driver, unfortunately. So.
Commissioner Paravaglia, Chair, this is Director Angela dropped again, and I just really wanted to state for the record, CCDA has always been accessible meetings. So I think, have always had that mindset to have access for anyone when we have a public event. So this idea of, I will say, Commissioner Paravaglia, you hit it right on the head on the nail on the head, something like that.
Yeah.
In terms of the formats, that's exactly the distinct differences. One is informal, even if it's virtual or not, or in person halfway or partly, we will create, it's still a more round table chatting, sharing about who we are. Presenting this document will always be kind of the back splash to all of our events for the legislative educational aspect. But the format of how we conduct it and what we're doing would be totally exactly how you described it. But the virtual in-person aspect of it, I think, is driven by the pandemic, if it's totally virtual or partial. And so, but overall, it was always going to be in a format that the public can have some form of access.
Okay. So, E&O is seeking some prioritization from us on these options. Is that correct?
So I would say that we would really want to make sure we're in line as we are starting to develop a outreach plan to ensure that that indeed is the wish of this committee. For example, I kind of feel already that it's a no-brainer regarding the list. We can always email, but in some ways I like to be maybe more productive to say we email with notifying them of an event. That was probably good, but either way, we could email and do it twice, for example. But the other two definitely needs a lot of fleshing out and determining which one is your prioritization, or if there's some additional thought to add to this list.
This is Commissioner Allen. My thoughts are, yes, the email list, of course, like you said, Angela, no brainer. You know, in marketing, they say that someone needs to see something 3 times in order for it to officially sink in and then become recognizable. So sending an email list once, don't think is going to get us anywhere other than maybe laying a foundation for a few. But if we follow that up with other emails, I think we would have a better outcome. I like the coffee chat. I think this conversation initially began with, how do we get our representatives to know that we exist? Because people don't know, and with every new election cycle, of course, we are having to inform new individuals, new representatives that we exist and what we do. So the coffee chat, I think, is also a basic need. I'm less excited about the roundtable. I think that for me, that would be the 3rd on my list. But if our goal is to get our state representatives to know that we are here and that we serve as advisors in a role for them to make their constituents' lives easier and better, then that's where we need to start. And I think that needs to be our initial focus. So yes, the email list, more than once to send it out, and then coffee chat, of course, based on accessibility. And I also love the idea of walking the halls. I'm in San Diego, but I would come up to Sacramento for a day and walk the halls and put and be a face to the name of CCDA if we get an opportunity to do that soon after COVID.
Yeah, and we also need to set our priorities in conjunction with Administrative Order 21 and to make sure that we are consistent with DGS policies in this too. So we'll, as that administrative order takes shape, we'll be molding around it as appropriate. Any other discussion on this item?
I think in terms of, this is Commissioner Lillibridge, in terms of my prioritization, I'm in 100% alignment with Commissioner Allen in that exact order. So if anybody's taking notes, which I'm sure they are,
Yeah.
that's how I am prioritizing the list as well.
Okay. Any
Chair
other
Commi-
thoughts?
Chair Commissioner Parvana, we have a hand raised from Mrs. Arias.
Okay, let's move to, if there are no thoughts from the commission, let's move to the public comment.
Thank you once again. This is Mrs. Arias from the U2 movement. I would love very much if you continue both in person and virtual. I'm in the city of Fontana, way far from you guys, and I will love to participate, continue to participate. I have 3 young, small students that also like to participate, but they have to do it virtual only as they have schooling to attend to. But I would love to ask you to please continue and be that example, because our local school districts don't want to do it both virtual and in person. And if you set the example as being the CCDA, this will set the stepping stone for others to follow. So please continue. Once we clear all out, this still should be both formats, virtual and in person. We would love to be there in person, but we can't because we're so far from you guys. And once again, we thank you for allowing us to participate by Zoom. Thank you again.
Sure. Thank you. Anyone else in the public? Hearing none. I think we've gotten what we need to out of this agenda item, Angela. So let's move on to agenda item number 5, receiving California Title III construction-related disability access legal complaints, update and discussion.
So Chair Paravanya and committee, we wanted to take the time to update you all on our strategic goal for this year, as well as the influence, the possible discussions from our partners and our colleagues. And that is why we've also, and gladly to hear that the State Bar is joining us today on this particular topic for discussion of receiving complaints from the legal community on Title III cases, case resolutions, and pre-litigation letters. So I wanted to just again state for the public record, our goal for this year was to evaluate compliance with CCDA's data collection mandate. CCDA will conduct a data research effort of the federal and state court systems to determine compliance within the 5-day notification process requirements of case filings and case resolutions. For this research, CCDA will conduct outreach also to the legal community to improve compliance. Our understanding is that there's opportunities in that capacity of possible miseducation and misunderstanding or unaware of their responsibilities to fulfill that requirement. We also wanted to look at, and this is why we're bringing back the government code, the civil code section 55.32 to remind this committee exactly what the law states. And then from there, I would like to see from any questions or comment on that. And then additionally, again, we have our partner in terms of a relationship of understanding how compliance is being monitored within state government, and that is our State Bar representative here today. So what I want to do first is to read some aspects of the civil code. and highlight just a few sections of it for your benefit today. First, again, is Civil Code Section 55.32, and 55.32A states, an attorney who provide a demand letter as defined in subdivision A of Section 55.3 shall do all the following. And I want to point out the aspect of an attorney who provides is a key factor in wording. And then with that, it says, and I won't read the whole thing, but sections that I think is important to note for this discussion. And two, within 5 business days of providing the demand letter, send a copy of the demand letter and submit information about the demand letter in a standard format specified by the California Commission on Disability Access on the Commission's internet website, prudent to sections 14985.8 of the Government Code to the Commission. This section of 14985.8 basically shares that CCDA has the authority to request a format, and that format must be given to the CCDA, or I should say, oblige the CCDA's request after 30-day notice. So we have 30 days to tell you that we want it in a particular format, and after that 30 days, they are to comply. So that's what 14985.8 basically talks about. The next point of 55.32, B says an attorney who sends or serves a complaint, which I think is another high point for this code. So again, it talks about who provides, who sends complaints. An attorney who sends or provides complaints as defined. And I want to skip down to the fact that in that type of complaint, they're to submit the date of the judgment, settlements, or dismissals. So again, we are to also receive the case resolutions for those complaints. Another point of reference in this, I should say the last two things I want to say about the civil code, if it says if the construction related accessible, so again, another point is it's construction related, not necessarily program, it's only referencing construction related accessible violations alleged in the complaint were not remedied in whole or in part after the plaintiff filed a complaint or provides a demand letter as defined. Whether or not it's favorable results were achieved after the plaintiff filed the complaint and provide the demand letter. These are also highlights of one of the biggest points that we made a good influence on the legislation is to say we're getting complaints, but we really, really need to understand what is the resolution. Are we seeing barriers removed? And that's another section of why it's important that we receive these resolutions and complaints. So this is the last thing I want to say. There was in this section that there was a notice that the state bar was receiving the demand letters as up to April the 30th, 2019, and they in section F, and annually submitting an annual discipline report. And this was produced by the state bar to the legislation and to the chair of the Senate and the Assembly Judicial Committees. So they were given a responsibility up until 2019 to submit to receive demand letters and also to report on them. That is no longer their role. in terms of demand letters. But I will say that I'm trying to think if there was a section that also identifies that the last on section I under H, that there is an area of which again, I guess I wanted just to highlight that it's only referencing construction related accessibility, and that there isn't any disciplinary responsibilities from CCDA in this, but it is a review, and this is a possibility of which we can talk about with counsel from the state bar, to talk about what type of disciplinary or opportunities there are still within state bar or within government code, because there isn't any direct disciplinary actions within this civil code. So we are recognizing that we do know there's some opportunities where attorneys, for example, may have started their license in 2017 and never seen this information, because it's not automatically sent to every lawyer who gets their license. This law came out back in 2013 and updated in 2015. So, and then another change of the law was for the state bar in 2019. So there's there is some opportunities in terms of education for our legal community. I think there's a little bit to digest enough to digest for now, but I wanted to highlight that we are halfway through the process this year of researching this effort. We began with first identifying what we've collected and comparatively what has been distinctively different that we compare to LexisNexis. And that's a tool that we have used compared to many folks who are using it in the public to recognize what is happening within the United States, because we see a lot of records and reporting overall from a number of private sector for federal courts. So that's what we're kind of using our basis to compare, but we're also just looking to see what registered cases are in this system that we have not received, and doing some research efforts on that capacity. But I want to dial back a little bit, just saying this is our civil code, and we are making this a year-long project. We're here midway through, and I think it's an opportunity for us to now do a little bit more outwardly looking, and that's where we went to the state bar to talk to them exactly what some of the discipline or research efforts they may have. And Council, I'm probably going to say your name wrong, Council Angie Esquiel. Yes, thank you. If you could share with us, I think that would be helpful.
Yes, thank you so much. This is Angie Esquivel speaking. So the role of the state bar is to look into any complaints that we receive from other agencies such as the CCDA or members of the public. Usually we get complaints from members of the public or opposing counsels indicating that an attorney has filed a ADA claim with the court and has not complied with California's Code Civil Section 55.32. So then the case gets processed from our intake unit to our prosecution unit, and I've personally prosecuted 2 separate violations on 55.32 specifically, and have worked with Ms. Jamat in the past regarding whether the attorney in those cases had complied with the reporting requirements as they relate to the complaints being served on the CCDA within 5 days, and also the case resolutions being served on the CCDA within 5 days. Many times attorneys will say that they were ignorant of the law and did not know that they had to report to the CCDA within the 5 days. However, things that the state bar will look into are how long of a lag time between the complaint was filed and the reporting requirement to the CCDA have they continued to violate or not? The two cases that I had in particular, they did continue to violate and did not remedy the issues quickly. So we went forward on prosecution on those cases. But I think that this is a great way to start and to build a relationship between the California State Bar and the CCDA, because what the State Bar wants to do is to avoid shakedowns of small businesses in particular, where oftentimes there may be an attorney that's filing these frivolous lawsuits on behalf of a client. So the State Bar wants to ensure that there is an actual client that's associated with these cases, that the attorney is authorized to practice on behalf of this individual, and that the attorney is complying with the regulations set forth in 55.32. Other issues that the State Bar would like to, that looks into, is make sure that there are no frivolous filings, that no fraud is being committed, and that the attorney is not misappropriating funds. Sometimes what we've reviewed and seen is that sometimes demand letters might be sent and to do a quick shakedown. So if an attorney were to send a demand letter on, let's say, 100 cases and you have a demand for $5,000 each, that attorney could quickly obtain a huge amount in attorney's fees. So that's something that we want to avoid in the moving forward in the future. And I think that building a relationship with the CCDA and the State Bar in whatever form that the CCDA decides to track the amount of complaints or filings that are, and case resolutions that are being filed by an attorney, it would be helpful to the State Bar if the CCDA thinks that an attorney is maybe gaming the system. A referral to the State Bar with this list of cases would allow us to investigate a little further and to ask the attorney, particularly with regards to those cases. Just making sure that I touched on everything. Are there any questions so far regarding anything I've said? And then just a quick closure note. One issue that I've seen that has come across my desk in particular is the lack of reporting requirements as they relate to website accessibility. Recently, I came across this issue. I noticed that there is not legislation in place regarding the regulation of attorneys and their requirement to either report to the CCDA within 5 days. So at this time, since there has been no legislation or statutes written into law, attorneys are able to get away with this, and the State Bar cannot regulate whether shakedowns are occurring. And I think that it's easier for an attorney to do a shakedown of businesses through website accessibility claims, because an attorney can quickly run either a bot or personally 100 or more cases within a day to see if particular websites are accessible to the visually impaired. And that's all the comments that I have.
Thank you so much. I really appreciate you being here and your information. And thank you for hanging in there through our meeting. I'm wondering one thing. From your perspective, do you see anything that the commission could be doing that would be helpful, improve the system?
I think one thing that might be helpful, I noticed I had an old case that where the reporting requirements to the CCDA required the attorneys to physically send in copies of the complaints that were being filed in state and federal courts. And at some point, I know that it changed within the CCDA to they were being electronically sent. So if there could be a way for the note taking of which particular cases are being reported to the CCDA, that would be extremely helpful for the State Bar, because sometimes attorneys report a different case number than what the CCDA has on file. Also, if there's a way to track the date of the filing of that complaint and the date of the case resolution, so that the State Bar can see how long did it take that attorney to report it to the CCDA.
Angela, is that something that can happen?
Yes, we definitely have the vehicle to do that. So that is some good feedback. And I wanted to say that what has been identified is probably something that needs to be clarified even more so for this committee as well as the stakeholders at large, because a section I forgot to read out and our council has been sharing is that in our N55.32, it does say a violation of the subdivision or subdivision shall be constitute cause for imposition of discipline of an attorney if copies of the demand letters, complaints, or notifications of a case outcome is not sent to CCDA in the standard format specified on the Commission's internet website, prudent 14985 government code within the 5 business days. So there is a language there that does talk about that they are required to send it to us, and there's an opportunity for imposing a discipline by the state bar. It is something that I don't think we really have engaged, as council has said, spending more time of saying, here's the bulk that possibly not in line with the 5 days. Our thing is those who typically are not within the 5 days are not submitting at all. And that's the problem more so than anything else. Those who submit typically are within the 5 days, generally speaking, but those who are ignoring or unaware are not. Once we get them, and as has been mentioned, there were some cases in the history that were over 200 cases that from one attorney that never submitted it. And that was clearly in communication with the state bar. And once the state bar spoke to them, they submitted their years of cases that they had not filed, which caused a great challenge for us in terms of staffing and workload when we get those bulks like that. And this is part of the reason why we really, we're positioned now, because it's electronically, we have a portal that we can really push to make sure that is no longer happening, because we can go after everyone who is not submitting and ensure that we are getting them, because we can handle it within our system.
Right, and if I may piggyback off of that, this is Angie Esquivel speaking. Ms. Jamot is completely right on that. I think that if both offices can just streamline the process, it would be easier for the CCDA to be able to have these attorneys comply with the requirements. At this time, it's difficult for the state bar to assess how many cases and what cases the attorneys have filed in state and federal courts, because there are so many courts. But if the CCDA has easier access to these type of complaints that are being filed by these attorneys, and that list can be sent to the state bar, it would be easier for the state bar to further investigate to see if any violations did occur. And in the 2 particular cases that I have prosecuted, one of the attorneys got a 90-day actual suspension, and one of the other attorneys was offered also a 90 days actual suspension. So if this is a huge issue, in particular for the CCDA, that the CCDA has attorneys that are not reporting at all, those cases can be, or those attorneys can be reported to the state bar via our online complaint system.
Good information. Any other comments from members of the commission? Hearing none, I always give a little extra time for folks to unmute. Again, I thank you for being here. I think that, keeping the dialogue going will be an important, value for both our organizations. Any comments from the public on this agenda item?
Good morning, this is Mrs. Arias. Yes, I do have a question for Ms. Esquivel. Is this true also for legal actions to and from the education, like due process complaints? Are they also to inform CCDA of these legal actions as well?
Ms. Arias, this is Angie Esquivel speaking. I don't know in particular what you mean by due process. However, if any member of the public or anyone at the CCDA believes that an attorney is violating some statute or rule or law, they can file a complaint on the state bar's website, calbar.ca.gov, and the state bar will do a preliminary intake review of that case. And if there's a callable claim, it'll be forwarded to the prosecution unit, and we'll investigate further into those allegations.
Yes, to clarify your comment, Due process is the legal term or the legal name for taking a child to court. It's called due process in the special education realm. Yes, the districts can take a child to due process or to court and vice versa as well.
This is Angie Esquivel speaking again. So if anyone believes that anyone's due process rights have been violated by an attorney, that complaint can be submitted online at the State Bar's website.
Thank you very much.
Okay, any other comments? Hearing none. Again, thank you very much for your information, and I hope that this is the beginning of a ongoing dialogue, discussion, and working relationship. Thank you.
Thank you very much.
Sure. Now we go to legislative bill tracking. It looks like we have about 5 bills. Is our representative from DGS with us this morning?
Hi, Commissioner Paravaglia. This is
Hi.
Coach Moore with DGS's.
How are you doing?
Affairs. I am doing well. Okay, so we can go ahead and do the update. We'll start off with AB 29. As we talked about in the last full commission meeting, this bill was held in the Assembly Appropriations on the suspense file, so it will not be moving forward this year. AB 105, the Upward Mobility Act, that is actually awaiting the final vote on the Senate floor. And then because there were amendments in the second house, it will then move back to the Assembly for concurrence in those amendments. And in all likelihood, it will probably be on the governor's desk pretty soon. This bill requires state boards and commissions consisting of 1 or more volunteer members to have at least 1 member or commissioner from an underrepresented community. And that provision applies only as vacancies on the boards or commissions naturally occur. And it applies to vacancy appointment by the governor, the chair of a board or commission, speaker of the assembly, the president pro tem of the Senate, or any combination thereof. Recent amendments as of August 31st added both veterans and persons with disabilities to the list of those who are part of a quote underrepresented community, end quote.
Thank you so much.
So that's been updated as of August 31st. AB 580 by Assemblymember Rodriguez. This bill is also awaiting final vote on the Senate floor before it goes to Assembly concurrence. And this bill requires the Director of the Office of Emergency Services to appoint representatives of the access and functional needs community to serve on committees that work to create or maintain a standardized emergency management system. And at least a majority of the appointees need to be representatives from the blind or visually impaired community, the sensory and cognitive disability community, and the physical disability community. Also, the bill requires that if it's requested by the local government, OES needs to review that county's emergency plans to determine if the plans are consistent with the best practices and provide assistance to local jurisdictions to help them meet needs of the access and functional needs community. Next up is AB 1429 by Assemblymember Holden. This bill was held on suspense in Senate Appropriations, so it will not be going forward. Next up, AB 1291 by Assemblymember Frazier. This bill requires a state body that limits time for public comment to provide twice the allotted time to a member of the public who utilizes translation services to address the body. And this bill has been signed into law and it'll go into effect as of January 1, 2022. I do have one more comment. There is a bill that is going through right now. It's AB 361 by Assemblymember Rivas. This bill would actually codify the existing flexibility measures that are in the executive order into the Bagley-Keene Open Meetings Act, and it would codify them through January 31st of 2022. So this just gives CCDA, BSC, all other state boards and commissions the flexibility that's currently in the executive order through the end of January 31st, 2022. And I'm not sure what's going to happen after that date, but that's just letting you know. This bill has not passed yet, but it is going through the process right now.
Just as a point on this meeting and access issue, what we've learned is that having meetings by Zoom or that people can access by Zoom has considerable positive impact, in the disability community, because people can participate who may not be able to travel because of the distance of the state or because of a disability. So one could argue that under 28 CFR 35.160, which is the Title II regs of the U.S. Department of Justice relative to ADA, that we must continue this practice to enhance effective communication, just as a FYI.
Yeah, there are other, a lot of other state boards and commissions have found that their participation has actually gone up since the executive order went into effect. And I think that's why we're getting the extension. And I think that there will probably be more talks between the legislature and the administration about how to keep this participation up going forward. So
yeah, I think it's good government.
Yep. So that was it for me. That was the only off item update.
Thank you so much. I appreciate it. Any questions from the commissioners? Hearing none, any comments from the public? Hearing none, I think we're through our legislation. Pardon me?
Mr. Paravaglia, you do have one hand raised from the public.
Okay. Please proceed.
Thank you. Well, I just wanted to echo the comments that were made regarding the accessibility to the public meetings. And I would hope that on the bill that was mentioned, AB 361, that we could also extend that to the Brown Act and not just the Bagley-Keene Act. I know the ACLU had a legislation, AB 339, that would apply to local school districts and municipalities. So I would urge the committee to support that concept, because I do think it is very important to continue the increased participation that a virtual format allows. Thank you so much.
Thank you. Anyone else?
Yes, this is Mrs. Arias. I too want to ask the CCDA to support any legislative that increases the opportunity for public participation. I've been struggling for a year and a half with my local district to be able to participate by phone or Zoom, and they have literally denied us that right. So if you encourage any law or legislation that allows public participation by other means than in person, it will be greatly appreciated. As I stated before, I have children with special needs that want to participate, but they are not able to do it in person. Thank you so much.
Thank you. Anyone else? Hearing none, I think that concludes.
Hello, this is Jessica Martinez.
Oh, okay. Yes.
Yes, and I would like to make public comment.
Go ahead.
Yes, sorry. You know, I have two children with disabilities, and I would also agree that allowing the virtual participation in public meetings, board meetings as well for school districts would be beneficial, not only to increase participation, but also to accommodate people or caregivers of children with disabilities. In regards to the bill, I would also like to ask the committee, to seek legislation to make it clear that the districts, school districts, that the Brown Act applies to special education students, because in many districts, for example, my district, Altaloma, they've sued my family and they sued other families without board approval. And so there isn't any checks and balances. You have for-profit attorney firms like Fagan, Friedman, and Full Frost who sue families, and there isn't anyone approving this litigation. So I would also encourage that. Thank you.
Thank you. Anyone else? I believe that concludes item number 6. I want to thank all who participated. And now we move to agenda item number 7, which relates to future agenda items for the legislative committee. Do I hear any suggestions about topics we may grapple with in the future? Hearing none.
Commissioner Chair Paravania, you do have a public comment for future agenda items.
Okay. Go ahead.
Good morning again. This is Mrs. Arias again. I would like to see as an agenda item the available, providing access to children with special needs to local meetings by means that is not in person, by phone, by Zoom, by any other means, because they don't need physical access. They need to have access in general. If you can please add that. And the second item, I'm a Spanish speaker. I don't see any access to our non-English speakers. I would love to see a person that can assist people who can need a translation, especially in Spanish, as most of our community members are Spanish. So some type of translation, please. That is actually an access to people that are not able to speak the local, the English language. Thank you.
Thank you. Anything else on future agenda items?
You have one additional hand up, Commissioner Paravani.
Go ahead.
Thank you, Rita Loof, and I just wanted to echo Mrs. Arias' comments on the future agenda items. And to add to that, I would hope that you would also consider the issue that's happening at the school districts, which, like Ms. Martinez mentioned, children are being sued. They're being taken through the due process proceedings without any kind of local government body official approval. It's being done underground by for-profit law firms that are working with administrators to deprive these children of their rights under the Brown Act. So I would hope that you consider that issue on a future agenda item. Thank you so much.
Mm-hmm. Anyone else? Are there any hands up, Angela?
I was just doing one more sweep, and no, I do not see any hands up.
Okay, our next item is adjournment, and the time is 11:15, and I'm adjourning the meeting. And just as a reminder, the meeting calendar will be distributed to commissioners for review on October 13th at the executive committee, and then we'll vote to approve on the 27th. So that's a preview of coming attractions. With that, we're done. Thank you very much for all of you who participated.
Excellent meeting. Thank you.
Sure.
Thank you so much for your time and attention.
Thank you.
Gracias. Thank you very much.